if you're the appellee, you've got 20 minutes. The first case this morning, I see you're all ready to go.
Yes, I am, Judge.
It's ARC Global versus Digital World Acquisition Corporation. All right, when you're ready, sir.
Good morning, Your Honors. May it please the court, if I may, I'd like to reserve 4 minutes
Got it.
for my rebuttal time. My name is Christopher King, and my firm represents the... Yes. Thank you, Judge. My firm represents ARC 2, and I'm going to give the argument for the appellants. The litigation between the parties in this case began with a complaint that was drafted by ARC 2's Delaware counsel to be filed in Delaware Chancery Court. And our Delaware counsel shared a copy of this complaint with the lawyers for DWAC who were in Washington, D.C., and told them we're going to file it immediately. Let's see if we can resolve this. The response that we got was they begged us not to file it. They said, you have it all wrong. Let's talk settlement. There was a question about whether I think the lawyer for DWAC said he had a medical issue. Give us a couple days. So as we're talking settlement, we agree. And as we're talking settlement, they filed this action in Florida. And it is a mirror image of our complaint in Delaware. And the dispute was this.
Wait, a mirror image of your complaint in Delaware?
That's right, Judge.
Okay.
The dispute was this. We figured out that they were trying to shortchange us on an anti-dilution provision in the DWAC charter. And there was a conversion ratio that protected us from having our shares diluted. And in addition to that, we contended, and so in our complaint, we asked for specific performance on our rights under the conversion ratio. In addition to that, we maintained that they had filed false statements with the SEC.
Mr. King?
Yes.
I appreciate the background information.
Okay,
I think we're all familiar with it.
Okay.
I think we need to sort of address what I sort of see as the big issue. I think your colleague on the other side makes a very compelling argument that this ship has sailed. You know, the complaint has been superseded a number of times. I think you're currently on the second amended complaint in the Florida trial court. The conversion ratio issue has been decided in Delaware, and it is limited to that discrete issue. It doesn't get into fiduciary duty. It doesn't get into bad faith. I mean, nothing. The trial judge up there was very adamant that wasn't factoring into what he was doing. So why are we here right now?
Well, we're here right now because the trial court departed from the essential requirements of law. And let me address what you just said. There's two responses to that. Number one, the Delaware case is not over. The trial court issued a ruling. There are appellate rights, and the Infinet case in the 4th District specifically dealt with this issue, that a failure to issue a stay and recognize the principal priority continues when there is a departure from the essential requirements of law, when the trial court is not observing that.
But before we even get to whether there was a departure from the essential requirements of law, we have to determine whether there was irreparable harm, because that determines our jurisdiction.
Let's get right to it. Let's talk about what the irreparable harm is, because I think we need to understand what the Delaware court actually did. They raised, and when I said this was a mirror image of our claim, basically what they raised in Delaware as affirmative defenses were, or is the same dispute that's going on in Florida right now. And the Delaware court didn't just say, hey, I'm not going to address these. The Delaware court entered rulings on this. Now there's an appeal, and they might have the ability to turn the judge around. But if we're looking at irreparable harm, and we're talking about the threat of inconsistent results, that's what we have here. We're on a collision course for that. Because what the Delaware court specifically said, and I'll just give you an example of of inconsistent results was that your allegations of securities violations, your allegations relating to mismanagement of the company, they're unrelated to ARC2's entitlement to shares. Now that relatedness issue is very much in the Florida case too, because they're seeking a disgorgement of all the shares that we've received. In order to prove disgorgement, they have to show relatedness. So right there, we believe, if we're looking at the standard on a stay, that the decisions that have come from Delaware, at least preliminarily before we have the appeal, resolve a lot of the issues in Florida. And
it seems to me that the Delaware case that you tried to get the stay based on was purely sort of like it was a formula set out in the charter. It was sort of just a mathematical determination and nothing beyond that, and the court made clear it wasn't going beyond that. Am I wrong about that?
Well, yes, because there was another aspect to it, which is we also sued them for breach of fiduciary duty for false statements they included in SEC filings. And in addition to that, let's understand, in the Florida case, our assertion of contractual rights under the conversion ratio is alleged to be extortion in Florida. And so the response to that is, look, we have contractual rights that we have the right to assert in this matter. And this isn't extortion. This isn't a situation where we're trying to gain some illicit advantage. These are ARC2's contractual rights. And so we have a ruling from Delaware that decides that issue. And it affects, and it should decide and take away the issue in Florida about whether this was a scheme to extort. So it all arises from the same nucleus of facts, which is the standard that we're looking at. And so, look, the bottom line on irreparable harm is this. This is a war over DJT shares. And if we get everything we want in Delaware, we still don't think that we've gotten the full satisfaction on our contract rights. Then we're going to have a judgment saying that they owe us even more shares than we've already received. And if they get everything they want in Florida, they're going to have a disgorgement award saying, ARC2, you have to disgorge all your shares. And those are two wholly incompatible results. And that's the reason why you have a stay, and that's the reason why the trial court really had no basis to deny a stay. These were the same cases and the same issues. It's just different parts of the same dispute. And so I think if we're looking at the stay issue, and I'll move on to venue also, because we do have two other issues. This was a departure from the essential requirements of law. We are on a collision course for inconsistent results in a very real way. Let's not forget the fact that their claims in Florida were affirmative defenses.
How were the same issues raised in the Delaware case versus the Florida case? That's the counterclaims on the judgment and
right.
affirmative defenses. Explain to me that.
Well, their claims in Florida, which are basically, there were alleged securities violations by Patrick Orlando and mismanagement. Are there affirmative defenses in Delaware? And so they tried to say that our rights to recover shares under the conversion ratio were precluded or barred by unclean hands and peri delicto, estoppel. And so it's the same issue. And also you have the same basic facts.
How was the same issue raised in Florida?
The same issue raised in Florida is those are their claims. They're claiming that there was a breach of fiduciary duty because of these alleged securities violations.
But
and
in a complaint, not in a affirmative defense.
That's right, in a complaint. So
the difference in the procedure, in the context, but not the substance, is what you're saying.
that's right. They're just putting just different clothes on the same underlying theories. And
Same color of red lipstick.
that's right. And so look, we think that this checks all the boxes for a stay. We don't, to answer your initial question, I don't think that the court can just deny a stay, ignore the principle of priority, and just allow full speed ahead on litigation to try to just get past it. I think that there are issues of irreparable harm here, and we do have real issues of how do we deal with these rulings from Delaware. Now we've got...
And that is still true with respect to the second amended complaint, which is what's currently in play.
Yes, yeah, and that's what I mean, because they really haven't changed too much about the underlying theories. They're still alleging that our insistence on the conversion ratio was extortion in Florida, when we say it was just our contractual rights. Now let me talk about venue. A couple issues immediately about venue in this case. One is, what version of the complaint do we look at? Because they filed an initial complaint. It was done in a hurry-up fashion. It was done as an anticipatory filing. And on its face, affirmatively, there was no venue in Florida. They sued for tortious interference with a merger agreement that has a mandatory form selection clause in it. And what the case law says is venue has to attach, venue attaches at inception. We have to look at the commencement of the case. We cited the Smith versus Randall case that talks about that. It's also built into the venue statute that it is mandatory to file an action in a court, only in a court that has venue. And so if you file in a court that doesn't have venue, where on the face of the initial complaint there's no venue, the court can't proceed. Now, they amended their complaint pretty quick, and so in our motion to dismiss, we talked about both versions of the complaint. So that's the other issue, which is, can you correct a situation where you file a complaint and clearly on the face of the complaint there's no venue? Can you amend? And the case law says no. But even if you could, we don't think they fixed the problem.
Well, let me ask you about your statement that the case law says no, because if you file a complaint that fails adequately to allege jurisdiction, I think you can amend it to correct that pleading defect, can't you? And you can amend a complaint to correct just about every pleading defect.
A pleading defect, well, it depends what you mean by pleading defect. I think
a failure to allege something that might otherwise exist at inception, right? I mean, an omission, a mistake.
Well, so the case law on this says that what you can't do is add claims or parties in order to fix a venue issue, and that's what the Smith versus Randall case.
What is the clear? Is there a reasoned holding anywhere explaining why venue would be treated differently?
Well, like I said, it's built into the statute. The court, the venue privilege attaches at inception. And so if you start out with a complaint that is clearly wrong, now maybe you misalleged something and you want to fix it. I think in that circumstance, maybe you could correct a venue allegation to fix it. We see that sometimes in federal court. And it's the distinction between does the court lack jurisdiction, or is it you just needed to fix some errors in your complaint? This is a situation where there was no venue at inception, clearly, on the face of the complaint. And the case law says you can't fix that because the venue has to exist at the start. Now, we still don't think that they fixed anything in their amended complaint, because what does the amended complaint do? The amended complaint, all it does is it switches out a tortious interference claim for a breach of fiduciary duty theory. And the only tie to Sarasota County is that, according to the face of this complaint, is that old TMTG, the old Trump Media before the merger, had its principal place of business there. And in addition to that, they say that they were harmed by the conduct. But if you look at the conduct under the allegations of this complaint, and specifically if you look at paragraphs 96 through 99 of their amended complaint, it is all conduct allegedly perpetrated by Patrick Orlando against DWAC. And so this is a Miami-Dade County resident who lives and works in Miami-Dade County that allegedly is mismanaging and doing things, self-dealing in Miami-Dade County, affecting a Delaware incorporated entity with its principal place in Miami-Dade County. There's no ties to Sarasota County. And the only allegation that this Sarasota resident alleges is a FDUPTA claim. And we know under FDUPTA that there has to be actual damages. And so just having the, what I would call the ripple effects of wrongful conduct directed to a different company affect you and cause you loss in Sarasota County, the cause of action doesn't accrue there. And that we cited the Fontana case that specifically talks about that. And there's also lots of case law that says that, look, it is legally impossible for a FDUPTA claim to arise on a theory of consequential damages because that's just not an element of the claim. And so if we're looking at an accrual on the basis of a cause of action accruing, where does it accrue? It couldn't, under any circumstances, accrue in Sarasota County under this version of the complaint, under either version of the complaint. And
That would be a failure to state a claim.
it would not be, well, it could be both, but it's a venue issue, Judge. And I know they've tried to argue that, you know, we're trying to argue motion to dismiss, but it's not that. It's a question of where does the claim accrue? And if all of your allegations are that conduct was perpetrated in Miami-Dade County against a Miami-Dade County resident, that's where it would accrue, or it would accrue in Delaware. It would not accrue.
I just want to let you know you're at 16 minutes.
Okay.
Sorry to interrupt.
All right, well, I rely on my brief on the other form non-issue.
May it please the court. My name is Sam Solario and I represent the Applees. I think it's worth taking a moment at the outset to kind of pause over how aberrant the opinion my friends on the other side are asking you to write would be. To get there, the court would need to write an opinion that says there's irreparable harm from a stay denial, notwithstanding the fact that at this point in the case, they have gotten everything they told the trial court they wanted, a decision on the merits of their conversion ratio claim in Delaware first. You'd have to find not just an error, but a departure from the essential requirements of law on the basis of an estoppel theory that was completely alien to the trial court and never mentioned. To write an opinion reversing on the venue question, the court would have to write an opinion that says that venue is fixed in stone, not by where the plaintiff alleges the cause of action accrued, but by the legal sufficiency of its allegations to state a claim upon which relief could be granted. Also an argument not made in the trial court, and an argument they forswore by telling the trial court the defect could be cured by amendment. And to get there on form non, you would have to say that the trial court abused its discretion, did something no reasonable judge could do by keeping a case that is solely among parties who are located in Florida on both sides of the V in Florida. I just think that would be a pretty extreme way to go. And so what I would like to do is first talk a little bit about the effect of the Delaware court's order, and then address what I think are the three most straightforward paths to getting the case decided. With respect to the Delaware order, I just think that order makes crystal clear that regardless of whether ARC follows through on its promise in its reply brief that they're going to appeal, there is zero probability that any ruling they could obtain on appeal would either conflict with any rulings the trial court might make in this very different case, or would be redundant of any proceedings in the trial court. I want to first say the issues that ARC can raise on appeal in its Delaware case have nothing to do with the issues in this case. ARC's claims in Delaware are and always were about what is the correct formula for calculating the conversion ratio under DWAC's charter. Those were the claims they pleaded, all three of them. I mean, even the breach of fiduciary duty claim was about you improperly computed the ratio and you misrepresented to investors how you were computing the ratio. That was the basis on which they resisted discovery in Delaware, and that was the basis on which the Delaware court held a one-day expedited bench trial solely on a paper record, because all this was ever about was, what's the formula? As concerns ARC, the Delaware court's order resolved its claims by saying, hey, listen, the conversion ratio should be higher than what DWAC says it is, but it's not what ARC says it is either. So what it did was, DWAC was saying the conversion was about 1.5 to 1. ARC was saying it's about 1.81 to 1. The court ruled the correct ratio is 1.49 to 1. The Delaware court also said that the breach of fiduciary duty claims ARC asserted were redundant of its conversion ratio claim. The harm was the same, the damages were the same, so there was no necessity to reach it. And you can find that at pages 4725, 4755, and 4758 of the R appendix. Now, I can see why ARC wants to appeal that. I mean, they basically lost. They got an awful lot less than they went in asking for. But nothing about the resolution of those questions, which are the issues that ARC can raise during its appeal, have anything whatever to do with the fact-intensive questions of what was Mr. Orlando's conduct and how did it affect old TMTG and DWAC that are pending in the trial court.
So your position is, although there's plenty of back and forth of allegations of wrongdoing, the ones addressed in Delaware are very different from the ones that are being discussed.
Yeah, I mean, it's as the Delaware judge said it was, which is this is basically a simple, straightforward case about contract interpretation. That's the case it resolved, and those are the issues that ARC can take up on appeal. Now, I think that the second point is that the Delaware court's order makes clear that the conduct challenged here never had anything to do with ARC's conversion ratio claims in Delaware, because it rejected DWAC's affirmative defenses that relied on that conduct on two bases. One, it said they were untimely asserted, and the other was they have no relationship to the conversion ratio claim.
So DWAC tried to sneak them in there, and the court said, I'm not even looking at those.
Yeah, not only are they untimely, the court said, but they also said basically they're not affirmative defenses to this claim. And you can find that at pages 4764 through 65 of our appendix. The court says the defenses are, quote, unrelated to ARC's claims about the conversion ratio, close quote, and that, quote, allegations of breaches of fiduciary duty and illegal conduct by Orlando have no bearing on the calculation of the conversion ratio, close quote. Those are not issues that ARC can take up. ARC's the beneficiary of those rulings, and it wouldn't want to anyway. And I think the third point I'd like to make here is they're kind of talking out of both sides of their mouth on this issue, because the claim they're making today is entirely inconsistent with what Mr. Orlando told the trial court barely a week and a half ago. And this will be included in this notice of supplemental developments we filed on Monday. It contains a March 7 hearing transcript. But basically, they're arguing now that this case should be in Palm Beach instead of Sarasota, where Mr. Orlando is anyway. And there was some back and forth with the trial court about this, in which Mr. Orlando's counsel admitted that the Delaware case is, quote, over, and that there's been, quote, a final judgment on that, close quote, and in which Mr. Orlando's counsel also represents to the trial court that the claims in the conversion ratio case are, quote, not related to the claims alleged in the second amended complaint, close quote, that is now proceeding in the trial court. And you'll find that at pages 31 through 32 of that transcript. Now, my friend mentions the issue of disgorgement of shares as a remedy in the trial court. Completely different question. The issue in Delaware was, what is the rate at which DWAC shares convert to new TMTG shares? That was the issue pleaded. That was the issue decided. The issue in Florida is, listen, because of all of the things you did that were faithless toward us, you should never have had those shares in the first place, and we're entitled to get them in restitution. The awarding of that remedy does not require revisiting what the Delaware court did with the conversion ratio, nor does it require undermining what the Delaware court ruled about the conversion ratio. All it requires saying is what you have, they're entitled to. And of course, that's not the only remedy we see. We see damages and all the rest. He also mentions the fact, and he says that that makes this case a mirror image of the Delaware case, that we call Mr. Orlando's demands about the conversion ratio extortionate. One, and I mean, you can look in the record, in the first amended complaint, it's at 78 of our appendix, and the second amended complaint, it's at 3406 of our appendix. But it's the toenail on the elephant. I mean, it's basically a sentence in a complaint that is overwhelmingly about an alleged conspiracy between Mr. Orlando and ARC and two representatives of Old TMTG to pre-target Old TMTG as a merger partner in violation of securities laws and in a way that delayed our merger, required the payment of SEC fines, required the payment of legal fees, and other sorts of business and reputational damage. That's what our complaint is about. This is kind of the toenail on the elephant. Secondly, even if he's right that it's really an issue in the Florida case and is an important point of commonality, well, one, it's just not an important point of commonality, but two, it doesn't require revisiting what the Delaware court did. I mean, the Delaware court said the ratio is what it is. It's an awful lot less than what they asked for in Delaware, so I think that's a claim that we can still maintain. So I'd like to kind of talk about what I think are the paths to affirmance here or dismissal, and I think there are three that are pretty straightforward. The first is I think the court can just dismiss the entire case as moot, and it's moot by virtue of either or both of the Delaware court's order and the second amended complaint. The stay order is just mooted by the Delaware court's order. Considering that ruling, there's just no chance that the fiduciary duty claims in this case, which are founded principally on the pre-targeting, will ever be asserted, litigated, or resolved in Delaware. The Delaware court's order confirms the case was always and exclusively about the computation of the conversion ratio, and an appeal is not going to change that given the issues ARC can raise. Insofar as this case is concerned, there's simply no Delaware case left for the trial court to accord priority to. But even if you thought we were wrong about that, the order so seismically affects the analysis under the principle of priority that an order or that a decision from this court quashing the trial court's order is not going to afford any meaningful relief. I mean, if you think about what this order does, first and foremost, it raises a special circumstances issue, which is discretionary with the trial court. That wasn't at issue before. I mean, I think what we would say is the case is over. It would be exceptionally hard for my clients to get relief and to assert the claims it's now asserting in Florida and Delaware because, among other things, we'd have to persuade an appellate court that the trial court's rulings on those issues were wrong. That's just delay plus duplication of efforts. I mean, this case is moving ahead. We're way into document discovery. Like, there's no purpose to doing it, so we'd have the special circumstances argument. The order alters the similarity of parties analysis. It makes clear that this was always and only a case between DWAC on one side and ARC on the other. It alters the similarity of issues analysis. It clarifies what the cases are about substantively: conversion ratio in Delaware, Orlando's misconduct in Florida. And it alters the analysis of which court first acquired jurisdiction because it clearly delineates what each court took jurisdiction of. So either way you look at it, the stay issue's moot. The venue issue's just mooted by the second amended complaint. I mean, to the extent there's ever been a venue issue in this case at all, it's whether any cause of action accrued in Sarasota County. Everybody agreed in the trial court, and everybody appears to agree here, that the venue statutes provide that in cases with multiple claims and parties, venue lies where any cause of action accrued, right? You now have a different complaint with new claims, new parties, and multiple claims accruing in Sarasota. The trial court has since heard and decided motions to dismiss for improper venue directed to that complaint. Their remedy should really be, if they want it, an appeal from that order. But at all events, it's well settled that an appeal from an order denying a motion directed to a complaint that has been superseded by amendment is mooted by the amendment. And we've cited scores of cases for that proposition in the brief. And I think it's worth noting that.
But is that true even if the first amended complaint should have been dismissed with prejudice? I mean, wouldn't that unwind everything that happened after it? So would that be an exception?
Well, but you would still be, then you would be dealing with our appeal from a motion on a final judgment appeal, right? Saying the trial court decided the question of whether this complaint stated a claim improperly.
And that would be immediately appealable.
Well, I think on the facts of this case, it would be as to us because it would have as to old TMTG because it would have dismissed old TMTG out of the case and.
But the failure to deny it on that basis wouldn't be immediately appealable.
That is correct. Yeah. Absolutely correct. But I do think it is. I do think it's important to kind of note that they agreed with this in the trial court. I mean, we made the argument, we can cure this problem by amendment. They did say, no, you can't, but they said, no, you can't because we don't think the allegation of actual damages is fixable. But, we made the argument, we can cure the actual damages allegation, and what they said, and this is at 1173 to 74 of our appendix, quote, now, Your Honor, could allow them to replead and then we would readdress venue. I believe that's the case, but I don't think they'll be able to do it, close quote. And then when the trial court asked them about it further, they responded, quote, if the FDUPTA claim, which is the only hook, is improperly pled, then there's no venue. So they can try to replead and fix the venue issue, fix the FDUPTA issue, and we'll be back here, Your Honor. I mean, they either conceded, abandoned, waived, or failed to preserve the argument that they're talking about on appeal with respect to this problem not being fixable. And it's also kind of wrong. I mean, consider the implications of it, right? Like a lawyer files a complaint and just by error or oversight makes no venue allegation at all. Or a party files a one-count complaint lacking sufficient ultimate facts to state a cause of action. I mean, I think what the implication of their argument is no amendment of those complaints would be possible because each of those complaints just failed to allege venue for one reason or another. And I just don't think there's any case law that supports that except for the 3rd District case that they cite in their brief, the Smith v. Randall case, which really contains no analysis and has never been cited by any other court for that proposition. In contrast, we've cited the 1st District's case in Wilner, which comes out and says, hey, listen, the filing of the amended complaint mooted this appeal from an order denying venue directed to the predecessor complaint. If I understand right, the appellants have also argued that the trial court couldn't allow the amendment because somehow that is outside of its jurisdiction because it messes with the order on appeal. I think that's wrong under 9.130F. The trial court has jurisdiction in the absence of a stay, and there's no stay here to proceed with the case all the way up to trial. What it did was made a decision on a motion for leave to amend a complaint. And I think the form non-argument is also mooted by the filing of the amended complaint. Apart from assertion, they don't really address that in the reply brief. And the reality is just that all of the factors weigh differently now. I mean, what you're talking about is a new complaint that adds new parties, new claims, new issues. And that all has to be evaluated under the key factors based on what it says. So I think mootness is probably just the cleanest way to dispose of the appeal. I think the second thing the court could do is dismiss the stay and venue issues for lack of jurisdiction, and then affirm the forum non-decision on the merits. On the stay issue, I think we've extensively briefed why there's no appellate jurisdiction over the stay order, and I'm not going to repeat that here. I think it's a very easy dismissal on irreparable injury. One, their brief, which serves as their petition, doesn't make a prima facie case of irreparable injury. They just say it's a stay denial, we've been irreparably injured. Two, they can't really deal with the reality of what the Delaware court's resolution of the claims does to their claim of irreparable injury. And then finally, even if you put some credit in the fact that they plan to appeal the Delaware court's order, I mean, I don't think it matters for the reasons I've explained, but how that's going to end up is entirely speculative. And the possibility that there could be inconsistent rulings or duplicative proceedings, which I think could be their only sources of irreparable harm, just seems awfully ephemeral. And cases say speculative claims of injury, don't do it in cert. Beyond that, I think this is untimely as a cert. And I mean, I actually think that the notice of appeal didn't invoke the court's cert jurisdiction, but I don't need to get into all that detail. I just think it's a simple, the cases recognize that when you're talking about converting an appeal into an extraordinary writ, there's some discretion around that. And this is a pretty easy case to exercise that discretion and just say, we're not going to entertain this now. I mean, this was not a case of a party seeking an improper remedy. It's a case of the party seeking the remedy it wanted, an appellate remedy with respect to the venue and forum non-decisions, and then deciding it wanted another remedy long after the time for seeking that remedy had expired. I mean, the stay issue was an afterthought in the trial court. It's at the back of their motion. It barely got attention in the reply. It barely got attention at the hearing. The notice of appeal specifically identified the venue and forum non-rulings and cited those provisions of 9.130 as the basis for the court's jurisdiction. ARC and Orlando sought a stay in the trial court and said, hey, trial judge, we are taking up your venue and forum non-rulings without mentioning the stay.
Mr. Slier, you're at the end of your time.
Oh, I apologize. Okay. The only thing I would I'll let it go.
Thank you. About 4 minutes.
Thank you, Judge. So let's start with the standard. It does not require there to be identical claims, identical parties. It has to be substantial similarities. And let me quote from their amended complaint, paragraph 64. ARC demanded certain adjustments be made to the ratio by which its shares in DWAC would be converted to new shares in the new merger entity. By withholding ARC's vote, both Mr. Orlando and ARC attempted to leverage DWAC into a less favorable bargaining position. This is central to their claims. And so there's no argument that these are dissimilar claims. They're very similar claims. And we maintain that a lot of the rulings that he referenced from Delaware wipe out their theories, especially on the question of relatedness. The vast majority of their damages that they want to get is the value of shares that the Delaware court has ruled that we have a contractual right to have. So there's no argument that these cases aren't sufficiently similar. There's really no argument that the Delaware court exercised jurisdiction first. There was a hearing on March 1st and an order, or there was an order on March 1st and a hearing within a few days after that in Delaware. Every single, and he just admitted that these are the parties are the same. This is a war between ARC2 and DWAC. Those are the two main parties. So, look, the stay issue was argued, it was preserved, it was squarely before the trial court, and the court should have granted that. And it would be an extraordinary, I think, opinion to say, look, a court can get it wrong on the stay issue, can ignore the principle of priority, can deny a motion to stay pending appeal, and just go forward with the case, and his rulings, which create irreparable harm, become appeal proof. And that just can't be the law. Now, let me also talk about his statements that we've taken inconsistent positions on this. At no point in the hearing that he just mentioned did anyone from our side, from Art 2 or Patrick Orlando, admit that the Delaware case is over. It's not over. There's still an appeal, and we did not get everything that we want for the prevailing party because we were able to prove that their conversion ratio was wrong. But there are still large categories of shares that we believe we're entitled to, and that we have a right to prove on appeal. And they have a right to appeal their affirmative defenses and the relatedness issue. The relatedness issue is a major issue in the Florida case. So one other thing, for our counterclaims in the Sarasota case, they've said that, hey, that's res judicata because you should have raised those in Delaware, which is an admission that they are the same case, that these are the same parties and the same disputes, because you couldn't prove res judicata without saying that it's substantially the same litigation. So we have all these thorny issues that we shouldn't have because this case should have been stayed at inception. And in terms of, what is the meaning of the prospect of an appeal? The 4th District addressed that question in Infinite. And so an appeal is a consideration in a motion to stay, and the stay continues until that litigation is over.
Well, let me ask you as a practical matter, because being here on cert, all we could do would be to quash the order denying the stay.
Right.
We can't direct the trial court to take any action beyond that.
We can't say, so trial, you need to unwind this all, you need to go, all we can do is quash. How does that play out in the trial court as a practical matter? Were we to determine that we have jurisdiction and quash the denial of the stay?
I think that is what the court should do, and also make a finding that you departed from the essential requirements of law by not staying it, and then the trial court would have to, obey this court's mandate and make a determination of a stay going forward. So I don't see how the court, after that ruling, could deny a stay at that point. So I think that would effectively.
Does it then go back to the time that it entered the order and revisit how everything was in that snapshot in time? Or would it have to then look at where everything is now and determine whether it would be appropriate to impose a stay now?
I think it would go back to the time, because I don't think that the court could subject us to the irreparable harm that we suffered, all the intensive litigation. And, it also goes to the venue issue. If the court didn't have venue, then all the orders, including 2 cert petitions that are pending before this court on discovery matters and contempt sanctions, all that would have to be vacated. And so, that would be my answer, which is yes, if you departed from the essential requirements of law and exposed us to irreparable harm, then everything that happened after that should be vacated as well.
Sir, you're at the end of your time.
Okay,
I appreciate
thank you very
that you were answering. Thank you.